There are over 30 types of visas that will allow you to enter and work here in the UK. And I have subdivided them into 5 categories. The first one is where you can enter the UK and you can apply for entry clearance where you don't have a job offer, or you can switch if you're here already in the UK. The second category is predominantly for the global mobility applicants. This is where you need to have an overseas employer in order to enter the UK. The third one is for those who would like to be here on a temporary basis, usually up to 2 years. Category number 4 is for those who would like to enter the UK and establish a business. This UK immigration category is called the Innovator Founder route. And the final immigration category is where I will be explaining all other work visa types which will allow people to work here in the UK. As you will see from today's video, there are a number of unique categories, and I'm sure that you haven't heard some of them. I decided to cover these other immigration routes so that you know that they exist, or in case you belong to this very small immigration category, so that you know your rights. If today's immigration categories do not apply to you, to your circumstances, you're very welcome to explore my other 4 videos which I've published in the previous 4 weeks. And now, guys, let us have a look at the other categories of UK work visas. As you can see, I've identified 5 of them. They are relatively straightforward UK immigration routes. However, they're pretty small niche immigration routes. So the first one is the international sports person. This route is for an elite sports person or qualified sports coach who is internationally established and can significantly contribute to developing their sport at its highest level in the UK. For those of you who know the UK immigration rules, you are probably aware that when the person's immigration route allows them to work in the UK, usually they are allowed to undertake any type of work, with only one exception: they will not be allowed to work as a sports person or as a qualified sports coach. And that is because there is only one prescribed route for those who would like to work in this capacity, and this is called the international sports person. So you'll need to have a governing body which would endorse your application. If you would like to have a list of the governing bodies, you're very welcome to head to my website, where I have provided you with links to the governing bodies that would be able to endorse the applications for the international sports people. And also, if you intend to enter the UK for more than 12 months, you will need to meet the English language requirement, which is quite rare for the temporary route. English A1 is a relatively straightforward English language test, and therefore I don't think you'll have any difficulty taking the exam. Just once again, I would like to remind you that if you are not from the majority English-speaking country and if you are not over the age of 65, you'll need to take the test unless you have a UK bachelor degree or the equivalent. Equivalent is when your course was either taught or researched in English language, and if it is the case, it has to be confirmed by ACTIS. In all other cases, you'll need to take a test. This test will need to be an approved test, a Home Office approved test, and also it has to be taken at the Home Office licensed and approved organization. The easiest way to find these organizations is to go to Appendix English Language, where they will provide you with all the necessary details. As with all other majority of UK immigration routes, you will need to meet the financial requirements. This is a very simple and straightforward one. You'd need to show that you have funds of at least £1,270 that was in your bank account for at least 28 consecutive days. And that is unless you have a sponsor willing to sponsor your application. In this case, they will need to mention in their certificate of sponsorship. The certificate of sponsorship, guys, by the way, should not be older than 3 months from the date of the application. So in this certificate of sponsorship, they have to mention that they will be sponsoring you and that this amount of at least £1,270 will be available for your use once you come to the UK. And this information will need to be inserted in the additional data section of the certificate of sponsorship application. This immigration route allows you to bring your spouse and your dependent children, those who are under the age of 18 and those who are not married. Despite the fact that this is usually a temporary route, For those who would like to come here, and for those of you who remained on this type of entry clearance or leave to remain for 5 years, they will be eligible to settle provided they meet the requirements. The next route is called the Minister of Religion. We already had a temporary route. This one allows those with a key leading role with their faith-based organization or religious order to come to the UK, and they will be allowed to settle after holding this leave, Minister of Religion, for 5 years, and you will be able to come here to the UK with your partner and with your dependent children. If your dependent child entered the UK under the age of 18, but during the extension process they've reached their 18th birthday, that's absolutely no problem, as long as you can provide proof that they entered the UK in this capacity when they were under the age of 18 and they are still dependent on you emotionally and financially, and they don't lead an independent life, and they are not married. So in these circumstances, their application will be extended in line with yours, and they will also be granted indefinite leave to remain despite the fact that they are over the age of 18 at the time when you apply. Minister of Religion is a points-based system application, and therefore you'll need to score 70 points in order to succeed in the application. So you'll get 50 points for proving that you have a certificate of sponsorship, 10 points for the financial requirements, and 10 points for the English language requirements. As I've already mentioned in one of my videos, this particular route, the Minister of Religion route, is a tricky one in terms of meeting the English language requirements, because it requires you to demonstrate a higher level of English proficiency in comparison to the majority of other cases. So for example, if anyone wants to apply for indefinite leave to remain, they usually have to show English language proficiency at the level of B1, whereas in this case you need to speak fluently English, and they would expect you to demonstrate skills at the level of B2. The same is for the bachelor degree students and master degree students and those who would like to study at the PhD course. Apart from these two exceptions, I cannot think of any other routes where they would require you to speak English language at the level of B2. The financial requirement is exactly the same as for the international sports person. That's £1,270, and the amount has to be in your bank account for at least 28 days. And that is unless you have a sponsor who is willing to help you meet the financial requirement. What is interesting, guys, with these routes and with majority of other routes is that if you're switching to this immigration category and if you remained in the UK for longer than 12 months, then you don't need to show that you meet the financial requirements, because it will be assumed that you have already automatically met it. So that's for someone who remained in the UK for longer than 12 months and they are switching to another immigration category. If the application is successful, the duration of the leave to remain or entry clearance will depend on the time which is inserted in your certificate of sponsorship. So it's going to be either the period which is on your certificate of sponsorship plus 14 days or 3 years and 1 month, whichever is the shortest. So if you are required to remain in the UK for 5 years, it means only that unfortunately you will only get your leave to remain or entry clearance for 3 years and 1 month. However, you will be able to extend it to up to 5 years, and you will be eligible to apply for settlement after remaining in the UK for 5 years, and of course after meeting the requirements for the ILR applications. The Scale-Up Worker Visa is a very interesting hybrid type of visa. That's a relatively new one. This is for talented individuals recruited by a UK scale-up sponsor with the skills needed to enable the scale-up business to continue growing. To meet the requirements, you will need to have a high-skilled job offer from a qualifying scale-up business at the required salary level. And of course, you'll need to make sure that your sponsor is on the list of the qualifying sponsors, and also that you were invited to work in a profession which has an occupation code which is listed in this appendix. With regards to the salary requirements, it has to be higher than £34,600, so that's the minimum amount. However, it should also be at the going rate or above. So what this means, the going rate means the minimum salary requirement for that particular profession. I would like to give you an example to help you understand how this works. So if you intend to work 39 hours per week, as a chief executive of a company with an annual salary of 65,000 a year, and that is gross, your scale-up work application will not be successful. And that is, guys, because although the salary is higher than the minimum £34,600 per year, it is lower than the going rate for this job type. As you can see, the occupation code for chief executives is 1115, and the going rate, the minimum acceptable salary for this position is £67,300 gross per year. And I draw your attention here, guys, that the going rates are based on a 39-hour per week work week. The frontier worker, this is a very niche type of work visa. So Article 26 of the withdrawal agreement gives frontier workers a right to be issued with a document certifying their rights as a frontier worker. And this document is also known as a frontier worker permit. Frontier workers do not need leave to enter or remain in the UK. In other words, they don't need a visa. And for this reason, issuing a frontier worker permit does not confer leave to enter or remain. It merely confirms it. The permit is the workers' proof of their right to work and access benefits and other services which they may be entitled to in the UK. And frontier workers can access healthcare, benefits and services according to the same rules as before the UK left the EU. And to qualify, you will need to continue to be a frontier worker. And in practice, this means maintaining equal treatment to the UK workers in matter of housing, healthcare and other benefits and services. Frontier workers will not need to meet the right to reside test, but they will otherwise need to meet the relevant eligibility requirements at the time when they make an application for benefits. Applications for frontier workers are free of charge, and applicants have a right of appeal if the Home Office refuses their application. Refusal decisions made on eligibility grounds also carry a right of an administrative review. So what are the eligibility requirements for these types of applications? You will be eligible to apply for a frontier worker permit if you are from the EU, Switzerland, Norway, Iceland or Liechtenstein. You live outside the UK and meet the requirements for working in the UK. With regards to working, you need to prove that you have started working in the UK while living elsewhere by 31st of December 2020, either as self-employed or unemployed, and you'll also need to prove that you did an eligible work. So what does it mean to do an eligible work? This means that you usually have worked in the UK as employed or self-employed person at least once every 12 months since you started working here, and your work in the UK is genuine and effective. In other words, it must be more than small one-off tasks such as an interview or participating in a one-off competition or audition or signing a contract. So if the application is successful, your permit will be granted for 5 years and 2 years if you meet the eligibility criteria as someone with retained worker status under Regulation 4 of the Citizens' Rights Regulation 2020. The good news is that frontier workers can also renew their permits for as long as they continue to be frontier workers. Sadly, guys, family members are not covered by the frontier worker permits, and if you would like to come to the UK as a family member of a frontier worker, you will need to apply in some other immigration category. Finally, we have the exempt category. Exempt category is when a person is not subject to immigration control. However, this doesn't mean that they should not apply to confirm their rights. So what usually happens, in order for someone to travel to the UK, even though they are in the exempt immigration category, they will still need to make an application just to have usually it's a vignette, which is placed on their passport to confirm that they are exempt from immigration control. There are 10 immigration categories. Because this is such a small immigration category, I will not be explaining 10 immigration categories. However, if you'd like to know more about this, you're very welcome to visit my website where I've written an article explaining 10 immigration categories. So these were our other categories of UK work visas.